Namaskar. Today we will discuss about the POSH Act Part 2. Part 1 has been already discussed. Now we will come to the inquiry into the complaint. Section 11 deals with the inquiry into the complaint. Then subsection 1 says, subject to the provisions of section 10, that is conciliation, the internal committee shall, where the respondent is an employee, proceed to make enquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and where no such rules exist, in such manner as may be prescribed. If prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case under section 509 IPC. Now it is under section 78-79 BNS and any other relevant provisions of the said code where applicable, provided that where the aggrieved woman informs the internal committee any terms or conditions of the settlement arrived at under subsection 2 of section 10 has not been complied with by the respondent, the internal committee shall proceed to make an enquiry into the complaint, or as the case may be, forward the complaint to the police, provided further that where both the parties are employees, the parties shall, during the course of enquiry, be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representation against the findings before the committee. Subsection 2. Notwithstanding anything contained in section 509 IPC, now 78/79 BNS, the court may, when the respondent is convicted of the offence, order payment of such sum as it may consider appropriate to the aggrieved woman by the respondent, having regard to the provisions of section 15. Subsection 3. For the purpose of making an enquiry under subsection 1, the internal committee shall have the same powers as are vested in a civil court under the Code of Civil Procedure 1908 when trying a suit in respect of the following matters, namely: A. Summoning and enforcing the attendance of any person and examining him on oath. B. Requiring the discovery and production of documents. And C. Any other matter which may be prescribed. 4. The enquiry under subsection 1 shall be completed within a period of 90 days. Then we will come how enquiry into the complaint takes place. Section 12 deals with action during pendency of enquiry. Subsection 1 says during the pendency of an enquiry on a written request made by the aggrieved woman, the internal committee may recommend to the employer to A. Transfer the aggrieved woman or the respondent to any other workplace. B. Grant leave to the aggrieved woman up to 3 months. C. Grant such other relief to the aggrieved woman as may be prescribed. Subsection 2 says the leave granted to the aggrieved woman under this section shall be in addition to the leave she would be otherwise entitled. Subsection 3. On the recommendations of the internal committee under subsection 1, the employer shall implement the recommendation made under subsection 1 and send the report of such implementation to the internal committee. Now we'll come to enquiry report. Section 13 deals with the enquiry report. Subsection 1 says, on the completion of the enquiry under this act, the internal committee shall provide a report of its findings to the employer within a period of 10 days from the date of completion of the enquiry, and such report be available to the concerned parties. Subsection 2 says, where internal committee arrives at the conclusion that the allegations against the respondent has not been provided, it shall recommend to the employer and district officer that no action is required to be taken in the matter. Subsection 3 says, where the internal committee arrives at the conclusion that the allegation against the respondent has been proved, it shall recommend to the employer, number 1, to take action for sexual harassment as a misconduct in accordance with the provisions of the service rules applicable to the respondent, or where no such service rules have been made in such manner as may be prescribed. Second says, to deduct, notwithstanding anything in the service rules applicable to the respondent, from the salary or wages of the respondent, such sum as it may consider appropriate to be paid to the aggrieved person, woman, or to her legal heir, as it may determine in accordance with the provisions of section 15, provided that in case the employer is unable to make such deductions from the salary of the respondent due to his being absent from duty or cessation of employment, it may direct to the respondent to pay such sum to the aggrieved woman, provided further that in case the respondent fails to pay the sum referred to in clause 2nd, the internal committee may forward the order of recovery of the sum as an arrear of land revenue to the concerned district officer. Subsection 4 says, the employer or the district officer shall act upon the recommendations within 60 days of its receipt by him. So, in case you have any thing in mind and you want to know further, you can call me or you can send your email or WhatsApp on my numbers. Thank you very much.